Greetings, my name is Ilona, and today we'll be critically evaluating the contemporary relevance and accuracy of the maxim in defining the extent of a landlord's property rights in both the earth above and the subterranean space below the land. The foundational principle of land law in the UK is based on the maxim of he who owns the land owns everything reaching up to the very heavens to down to the very depth of the earth. It once represented an era where ownership of land was absolute. This principle made sense centuries ago when land was viewed simply as a physical space on the surface with little interference above or below the surface. To a small extent, the maxim continues to influence property law today, but it does not fit in the same way as it did before. The maxim's practical relevance has diminished over time due to society's modernization and technological advancements. Modern law regards the land as a 3D aspect. This horizontal concept of land evolved into 3 dimensions, that is, the surface, airspace, and the subterranean layer below, which was defined under Section 205, subsection 1, paragraph 4 of the Land Law Property Act 1925. It defined land as including any tenures, mines, or minerals above or beneath the surface. Therefore, this presentation will discuss how relevant the maxim is in the current statutory framework and how laws and courts' decisions have altered the view of absolute ownership to represent the day-to-day understanding that owners have limited rights over both the airspace and the subsurface. To be able to understand the relevancy of the old maxim today, it is important for us to understand its origin and historical significance. The maxim is historically rooted in the medieval commentary on Roman law, which eventually became the foundational principle of land law in England. During the feudal period, land ownership was absolute. All land technically belonged to the crown, and people were acquired estates in exchange for loyalties or services. Land reflected an ultimate source of power, wealth, and control, as well as social status. The maxim primarily remained relevant for centuries as it aligned with the limited vertical dimension of human activities in pre-industrial society. Human activities in the past were mainly surface level because goods were mainly produced on an agricultural basis. Trade and e-commerce were small scale and local. Thus, there was no need for aircrafts, complex airspace regulation, or even underground structures. The maxim was applied and referenced in several cases, particularly Benton's case and Pickering versus Rood in 1815 by Lord Ellenborough. Nonetheless, as early as 1985, legal scholars such as JBT started to question the practicality of the maxim. When taken literally, the maxim was deemed sweeping, unscientific, and unpractical, as Lord Wilberforce subsequently noted in the case of Commissioner for Railway versus Valuer General later in around 1974. Due to key historical developments, the notion of land ownership under the maxim began to evolve. From the decline of the feudal system to the shift away from constitutional monarchy, along with the Industrial Revolution, which brought about several technological advancements and new infrastructures such as aircraft, drones, skyscrapers, mining, and oil drilling, led human activities to be increasingly beneath and above the surface, which all gradually redefined the boundaries of land ownership. As a result, courts nowadays have interpreted the maxim to mean that landowners can only own as much of the airspace and subsoil as they can reasonably use and control for their own enjoyment of the land. Therefore, any land beyond that does not belong to them. Now we shall have a look into how the law surrounding the current dimension of land, particularly airspace and subterranean space below, has been refined through judicial precedents and current statutory frameworks. The contemporary ownership of airspace has been now categorized into 2 levels. Firstly, the lower airspace, which belongs to the landowner for their ordinary use and enjoyment, and any interference without the landlord's permission will amount to trespass. as established in the case of Kelson versus Imperial Tobacco 1957, where the defendant's advertising sign projected over the claimant's shop frontage. The court held that such entrenchment amounted to actionable trespass because it interfered with the claimant's use and enjoyment of the airspace. Thus, the case established that any intrusion will amount to trespass due to the fact that a landlord's rights extend to the lower airspace of his property to protect one's use and enjoyment of land. However, one can argue that the case of Kelson versus Imperial Tobacco did not limit nor define the upper limits of the airspace ownership. Such limitation was later refined in Bernstein of Ley versus Skyviewers 1978. In this case, photographers from an aircraft took pictures of the defendant's country house from above. The defendant sued the company for trespass above his land. This issue was whether a landowner has authority to stop an aircraft from taking pictures or flying over their property as long as it was in a reasonable height. The High Court of Justice held that the aerial photographers were not trespassing. The court established that a landowner's right shall only extend up to the airspace of that a reasonable person can ordinarily use and enjoy. Anything above that airspace is for public use. As a result, the case of Bernstein limited the scope of the old maxim whereby landlords could no longer own the infinite vertical space, but they are still protected in the lower layer of the airspace. In addition, such provisions were further introduced to support the common law limits of airspace ownership. For example, under Section 76, subsection 1 of the Civil Aviation Act 1982, states that a landowner has no right to bring an action for trespass against aircraft flying at a reasonable height in accordance with the Civil Aviation Regulation. This provision, along with the Civil Aviation Authority, ensures that upper airspace remains public rather than private. To strengthen such regulations on airspace ownership, the Town and Country Planning Act 1990 and other related legislation restricted the rights of landowner to build in the lower airspace, requiring planning permissions and compliance with development controls. Such principles have been later reinforced in later cases, such as Anchor Brew House Developments versus Berkeley House Development Ltd., where it was stated that even the least interference with the lower space will amount to actionable trespass. Hence, airspace ownership today is heavily regulated at every point and balanced between private ownership rights and public safety and technological advancements. Moreover, lengths of the subterranean space have likewise evolved and refined by courts. For instance, the case of Gillespie versus Melvin 1974, the Court of Appeal held that the defendant was not entitled to an easement to use the cellar underneath the party's house. As a result, the court reaffirmed the principle that ownership of land generally carries with it everything beneath the surface. Likewise, basements or cellars as part of the property, unless ownership is clearly separated in writing. Parliament, however, still ensures that the Crown had control over certain subterranean resources for public benefits and national interest. For example, the Coal Industry Act 1994 gave the Crown ownership of all underground and coal mines, and the Petroleum Act 1998, Section 2, Subsection 1, says that all natural gas and petroleum beneath the land belongs to the Crown. In addition, Mines Act 1966 gave businesses and authorities to access and drill through the surface, even without the surface owner's consent, followed by the Water Industry Act 1991, which gave water authorities the legal authority to build and maintain subterranean pipelines and sewers for public use. More importantly, the now leading authority which has revised and established that subterranean ownership is not absolute is the case of Bocardo versus Star Energy 2010. In this case, Bocardo sued Star Energy for drilling pipelines deep underneath its property without permission. However, the company has been granted license by the Crown underneath the Petroleum Act 1998, which enabled them to drill wells that pass beneath 800 to 2,800 feet below Bocardo's land without the need for his consent for them to be able to reach the oil reserves. The issue was whether the landowner's rights extended that far in those depths below. The Supreme Court held that yes, deep oil drilling operation through hundreds of meters of land space constituted the trespass, but it was not awarded a small damage. It was only awarded a small damage, actually, of 100 pounds because the interference occurred at a depth that did not affect the land usage. Therefore, the case established that a property owner's right extend beneath the surface until any intrusion interferes with how they normally use the land. Judges agreed that one does own some subsurface area, but not endlessly. Only the depths enough to make reasonable sense. The significance of this case is that it shows that the idea of to the depths is outdated. It is no longer practically relevant, actually. In addition, it established that owning land comes with practical laws instead of unlimited control. Thus, it draws a line between the personal property claims and public rights, while also highlighting that a new technological advancements such as drilling pushes judges to refine where ownership actually ends. Hence, one can conclude that to a larger extent the relevancy of the maxim, he who owns the land owns everything up to the very heavens and to the very depths of the earth, has declined significantly. As society modernized, the principle itself made little to no sense to be followed, which led to courts refining it through cases such as Kelsen and Bernstein, along with other statutes to support such decisions, which sets the boundaries between the lower airspace and the upper airspace. Similarly, the case of Bocado versus Star Energy, where the Supreme Court established that property rights extend to underground areas, but only when owners can effectively control and benefit from them, but the state retains ownership of deeper layers through Petroleum Act 1998 and similar statutes. Until today, society continues to develop more, and advanced technologies are now being invented more than ever. It is important to note that living accommodation are also not like in the past, and there are taller buildings with different owners. Some are living upper, some are living below, and it's difficult for people to actually own from down to the depths to up to the heavens. It's not practical, it's not realistic. Human activities such as aerial photography, skydiving, aerial surveying, altogether makes the maxim impractical, as mentioned in this day and age. Hence, the maxim's principle of absolute ownership has too many practical limitations, which reduces its relevancy significantly. Thank you for listening.